What are we doing?
I'm going to be requesting an adjournment. I believe I did provide a green sheet to the court.
Yes, you did.
Right from the opening seconds, the courtroom gets straight to business. The attorneys and the judge are immediately discussing a bond violation, which is one of the most serious issues a defendant can face while out on release. When someone is granted bond, the court is essentially saying, "We trust you enough to remain free while your case moves forward." But the trust comes with strict conditions, and breaking those conditions puts the entire release in jeopardy. In this situation, the defense attorney is preparing to address that violation on behalf of Anna, and the judge is already signaling that he wants answers. Notice the phrase "green sheet" mentioned here. In many courts, that refers to documentation submitted to the judge ahead of time, often containing details about violations, treatment plans, or recommendations. The tone of the judge is calm, but make no mistake, bond violation hearings are serious. Judges must decide whether the defendant deserves another chance or whether the violations show that the person cannot be trusted outside custody. As this hearing unfolds, pay close attention to what evidence is presented. The court will examine drug test results, missed tests, and the timing of the defendant entering treatment. Those details are going to shape everything that happens next.
You want to address the bond violation?
Yes, John, with regard to the bond violation, I believe Ms. Donnell would be prepared to admit to it, and she has checked herself into treatment.
I do struggle with addiction, and I am currently have checked myself into Spera Recovery Center.
To where?
Spera Recovery Center. It's detox. Excuse me, I don't mean to interrupt you. I did a level of care assessment. They recommended a 30-day program, and then I hopefully will go to transitional housing.
I don't have any of that.
Your Honor, I did provide that to the court.
And I have spoken to my bond advisor as well.
Where is the Dawn from? Is she in currently?
Yes, Your Honor.
Was she in at the time of these?
I believe she checked herself in after the violation. Is that correct, Ms. Donnell?
I found out about my violation actually.
Which violation?
I'm sorry, what? Yes, I've been struggling a lot, if I may speak.
I have 1, 2, 3, 4, 5, 6, 7
May I adjust?
tests for cocaine.
And Ms. Donnell, my understanding is that you...
And are you on a prescription that's an amphetamine?
No.
And so 3 tests with the cocaine that also tested positive for amphetamines.
This is the moment where the judge starts laying out the actual evidence behind the violation, and it's not looking good for the defense. According to the court records, multiple drug tests came back positive for cocaine, and on top of that, those same tests also showed amphetamines in the system. Now in court, drug testing results are taken extremely seriously. They're objective, documented evidence, and unless there's a valid prescription or a lab error, they're very difficult to dispute. When the judge asks about a prescription for amphetamines and the answer is no, that removes one of the most common explanations. What makes this situation worse is the pattern the judge is describing. We're not talking about one questionable test. We're hearing about several positive results and missed screenings. And in the court system, a missed test often carries the same weight as a failed test, because it raises the suspicion that the person avoided testing to hide drug use. This is why Judge Simpson's questions are so pointed. He's not just asking what happened, he's evaluating whether the defendant's explanation lines up with the documented timeline. And here's something worth asking. If someone enters treatment only after several positive tests, should that count as accountability, or does it look like damage control?
Then on January 13th, she missed.
Yes, Your Honor. And she will freely admit that to the court, that this is the result of Stroh's addiction, and that she has now checked herself into Spera for detox.
No, that's not going to be good enough. You didn't do that until when?
I've been there since Saturday.
Yeah, that's the problem. These tests, and you say it's because you were struggling with these, and that you also got a notification of a positive test. Your positive test date back to November 26th.
There was, may I speak?
Yeah.
The first test I had was positive, and it was a false positive. So I sent that out, and it came back negative. Then after
What
that,
test is that?
the very first one,
On what date?
November 26th, probably. After that, I have struggled with addiction. I went to Oakdale for 3 days. I got out and I've been homeless, and I didn't have a place that was substance free, and I continued to struggle.
This is where the emotional side of the case begins to emerge. Anna openly admits she has been struggling with addiction, and she describes a situation that unfortunately appears in many courtrooms: short stays in detox programs, unstable housing, and relapse cycles. From a legal perspective, judges hear these explanations frequently, and they have to walk a very fine line. On one hand, addiction is widely recognized as a serious medical and psychological issue. Courts across the country have developed treatment programs and drug courts specifically to help people recover rather than simply punish them. But on the other hand, bond conditions are not optional. When someone is released from custody, they are agreeing to follow strict rules, including staying sober and showing up for testing. Anna's honesty here could help her credibility. She's not denying the addiction, and she's acknowledging responsibility for her substance use. However, the judge is still looking at the timeline of violations, and that's the piece that often determines whether someone keeps their bond. So the real question becomes this: is the court hearing a story of someone trying to recover, or someone explaining repeated violations after the fact?
I take responsibility for my substance use, and I continue to struggle, and if I have to go to jail, like, I understand that. But I didn't know I had a bond violation like warrant out for me until after I went to Sparrow.
Till after you went?
Yes. But I assumed it would happen eventually anyways. I'm just surprised it didn't happen sooner. I struggle with addiction.
I get that, man.
I know.
And I don't know why you're not an inpatient when I'm looking at this.
I am an inpatient.
For 30 days.
Correct. I'm here with an RSS, a recovery support specialist with me.
Maybe I should have put it this way. Why weren't you in there earlier?
That single question from Judge Simpson cuts straight to the heart of the case. The court is not just evaluating whether Anna is in treatment now. It's asking why treatment didn't happen months earlier, when the first positive drug tests began appearing. This matters because judges often distinguish between proactive rehabilitation and reactive rehabilitation. If someone voluntarily seeks treatment before violating bond conditions, courts usually view that as a sign of responsibility. But when treatment starts only after violations pile up, the court may see it as a response to legal pressure. Anna admits there's no excuse, which is an important moment. In many hearings, defendants attempt to blame misunderstandings, faulty tests, or outside circumstances. Here, she openly acknowledges that she expected consequences. Judge Simpson's tone here is interesting. He's not dismissive, but he's also clearly skeptical. He's trying to determine whether continuing treatment is worth the risk of leaving her out on bond. And that decision is coming very soon.
There's no excuse. I went to Oakdale for 3 days for a little like detox thing, and I got out and I was like, oh, I got a job, I'll be able to do that. And I was still struggling so much I didn't follow through with the job. So as soon as I realized I wasn't going to be able to do the job, I got myself into inpatient. I shouldn't have expected myself to be able to work a job when I was getting high.
Where are the amphetamines coming from?
I don't know. That may be a medication I'm taking or something. Or something in this. No, I don't like, it's difficult to be up here talking about, hey, I struggle with this in the first place.
And you're saying the reason that you missed your recent test is because you're an inpatient?
Correct.
It's a 30-day, and so when are you expected to be done with this?
I checked in on the 10th, so roughly about the 9th or 10th of February.
Adjourn this to February 12th, 2026 at 9 a.m. That's for PCC and sentencing on the violation. I will let you continue in treatment, but you are to get over to community corrections for placement on a tether, location tracking tether.
Thank you, Your Honor.
Here's the judge's decision, and it's a compromise ruling. Judge Simpson allows Anna to continue her treatment program, which means he is acknowledging the effort she has made to enter rehab. But at the same time, he imposes a new condition: electronic monitoring through a tether device. A tether is essentially GPS tracking. It allows authorities to monitor the defendant's movements at all times. Courts often use this tool when they want to give someone another opportunity but still maintain tight supervision. This ruling shows the balancing act judges perform every day. If the judge had revoked bond entirely, Anna could have been sent straight to jail. Instead, the court is giving her a chance to prove she is serious about recovery, but under strict oversight. What happens next will depend entirely on whether she follows through with treatment and obeys the new conditions.
Her bond will continue otherwise.
Thank you. Should she go over there now?
She better.
Okay.
Sorry to interrupt you. Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. Douglas.
Your name?
Good morning, Your Honor. This is Sean Douglas.
You're requesting an adjournment.
Yes, Your Honor. I also have here, after Mr. Douglas gets a chance to sign it, a referral form to mental health treatment court.
Got it. I don't know what their timing on everything is. But there you go. February 5th, 2026, 9 a.m.
And Your Honor, may we address bond as well?
Briefly.
Thank you. Your Honor, Mr. Douglas is in a vastly different situation than he was when he missed court previously. He now has stable housing. He has a support system, which includes his father, his roommate, and several friends, and Ozone House. He also now has a bus pass, so he has stable housing and transportation so that he could return to court. We are asking that the court consider a personal recognizance bond for him so that he can show, Your Honor, all the improvements and efforts that he's made.
Now the courtroom moves to another defendant, Sean Douglas. And this case involves a very different legal issue, a request for bond reduction. A personal recognizance bond means the defendant would be released without paying bail, based solely on their promise to return to court. Defense attorneys usually request this when they believe the defendant has strong ties to the community, stable housing, family support, employment, or other factors that show they're unlikely to flee. Douglas's attorney argues exactly that. She describes stable housing, a support network, and improved circumstances since the last hearing. But the judge immediately brings up something that changes the entire equation: weapons charges. In the court system, weapons-related offenses are treated with heightened concern because they can pose a potential risk to public safety. Judges must consider not just whether someone will show up to court, but whether releasing them could endanger others. And Judge Simpson makes it clear he still needs a full mental health court assessment before considering any bond change.
Any response from the people?
Mayor, I'd leave it up to the discretion of the court.
I've got a concern that we don't have a full assessment of him, and I've got weapons charges. That's a big concern to the court.
I understand your concern. It is my understanding, Miss Ikiri has been in communication with Mr. Douglas's father, and it's my understanding the mother is the complainant, and that she is at this point asking just for him to be held responsible for the damages to the vehicle. So I'm not excusing his behavior, but I think this is a family situation and a little more complicated.
Right, but until I get an assessment, given all of that, I'm not going to change anything. He's going to stay right where he is. See, the motion for bond reduction is denied. I'm going to leave him there. Maybe once there is the assessment or initial assessment for mental health court, I'll have a better picture of it. But under these circumstances, I'm not doing it. All right.
I think
you.
Shalisa Floyd.
Thank you.
Your Honor, requesting to adjourn this matter. We're still waiting for some discovery.
This moment shifts the courtroom into another procedural phase, discovery delays. Discovery refers to the exchange of evidence between the prosecution and defense. It includes things like police reports, body camera footage, witness statements, and forensic evidence. Here, the defense explains they are waiting for a WatchGuard link, which likely refers to video footage, possibly from police body cameras or dash cameras. Without that evidence, the defense cannot properly evaluate the case or prepare arguments. Judges often grant adjournments in situations like this because both sides must have equal access to the evidence before moving forward. Rushing a case without full discovery could lead to appeals or claims of unfair trial preparation. But something interesting happens in this moment. Instead of the lawyers doing all the talking, the judge begins speaking directly with the defendant about her job situation.
How soon do you have it? I mean, if we're waiting discovery.
So I believe it's supposed to, we requested it the other day and I was supposed to be receiving a link, a WatchGuard link for the discovery, but I never received that link. So
you give it to them as early as next week.
So 2 weeks.
Can we? Oh,
What did you want to say? You wanted to say something?
yes, sir. I was just.
I'll talk to you. I like talking to you more than I like talking to them. So go ahead. What do you want to tell me, ma'am?
I was just gonna say 2 weeks because I'm starting a new job at Chrysler, so I don't know what my schedule
Your
is gonna be.
schedule's going to be?
Yes, sir.
All right. So when do you start that?
Next Thursday.
So you start that on the 22nd?
Yes.
All right. And then you're going to have to get to your attorney. Everybody's going to have to look at it. While we're doing all that, you don't want to lose your job.
No, sir, I don't. Thank you.
And here's what I'm going to do. I'll put the probable cause conference out to February 12th, 2026, 9 a.m. And she's working and doing that. If she can find a way to get it done, then she submit the forms, let her appear via Zoom. And we'll try to time it up so she won't lose the job. You're welcome.
Thank you.
See, if they had said it, it would have all turned in and I would have just denied everything. But the way you asked.
This is a rare and revealing moment where Judge Simpson actually explains part of his decision-making process out loud. He tells the courtroom that the way the request was presented affected how he handled it. Judges hear dozens of motions every day, and how attorneys frame their requests can influence the outcome. In this instance, the judge is essentially saying that if the request had been presented differently, he might have denied it outright. It's also a reminder that courtroom communication matters. Lawyers are not just presenting facts, they are persuading the judge through how they structure their arguments. Moments like this give viewers a glimpse into the human side of the legal system. Judges are bound by law, but they also rely on judgment, discretion, and interpretation when making decisions.
All right.
Address bond, sir.
Pardon?
Can we address bond also, sir?
Your bond?
Yes, sir.
Oh, you're telling her what to say now?
If she asks, you won't deny it.
All right. What about her bond?
My bond condition.
Your Honor, she has right now, there's a no-go to her current house where she lives, so she's not able to go there. So we are asking if we could change that to allow her to go back home. Right now, she's been living at friends' homes and she's still paying rent and mortgage on that home that she can't go to.
Your Honor, the people that oppose the modification to the bond, no go to, especially as the complaining witness is currently residing at that location. He is in the process of moving out. He's asked us to get at least 2 weeks for him to be able to do so. But at this time, he would like the no go to.
Your Honor, it's her home and he has no right to be staying in that home at this time
So how do you get in there?
because there's the no-go.
No.
Originally he was staying with her as
Yeah.
but not as a resident there. It was just a one-time thing.
We were dating.
What?
We were dating. I'm in love with him. I am in love with him.
Okay. That's fine. I get that. And I guess that was going to be my point. I understand it may be her home, but I don't really think if this court's going to be consistent, I'm not going to change that where that person is still in the premises.
So in 2 weeks, he indicated that he's moving out within 1 to 2 weeks. Should we?
Well, here's the problem. Even if she doesn't or he doesn't move, then she's just caught at that point. I'm not going to change it to allow him to go or allow her to go back until he's just vacated the premises.
Your Honor, when we receive confirmation that he has left the premises, I will reach out to defense counsel. We can submit a stip to allow her to return to the address.
Well, I've given him an eviction notice already.
Okay, that's going to be a whole other problem because whenever people are in the middle of a domestic,
I didn't give.
Where's the property?
It is.
I don't know if that comes here or not. That's in Washtenaw County.
Yes, yes, sir.
Right next to Ypsilanti.
Is that 14B? Is it 18? Well, there's only. Well, if it comes before me, I'm going to throw it out because I don't allow eviction cases on domestic cases either for very good reason. So he needs to just move and then there'll be the stipulation and you can go back.
Thank you, Your Honor.
Okay, bond will continue.
Thank you.
Calls the case, People versus Derek Graham.
People.
Joy Haynes, Senior Assistant Public Defender, with and on behalf of Mr. Graham.
Your name?
Derek Graham.
Thank you. What are we doing?
Your Honor, at this time, Mr. Graham has indicated that he is not interested in any kind of plea agreement. He wishes to set this for preliminary examination and to have our office address bond.
And what?
And to have our office address bond.
So discover his complaint.
That is my understanding.
Do you have other witnesses available the 27th?
Yes, Your Honor.
Preliminary examination in person, January 27th, 2026, 9 a.m. before Judge Washington. Bond will continue. Or you want to address bond? Go ahead.
Thank you, Your Honor. Your Honor, Mr. Graham is indicating that he has stable housing. He has Section 8. He is asking that the court consider that so that he can return to his housing and not and be able to maintain his voucher. He also is in the process of gaining custody of his son. He indicates that he does have a friend of the court hold.
That's what?
A friend of the court hold out of another county for his child, and that he believes he will be able to post for that as well. Post for that.
The friend of the court?
To the friend of the court to a different county, and that he will be able to make that payment towards his arrearage to that court and would be able to be released if Your Honor would allow him to have a personal recognizance fund. He's also an entrepreneur. He has his own business.
Response.
Your Honor, the people who oppose reduction in bond, the defendant in this case said harassing text messages to the victim, in which he says, "I'm about to go to jail, fuck it, I just want this shit over with. I promise one of us is about to die tonight." Those statements are of great concern to people.
Those alleged statements are from July.
From what?
From July of last year.
So that makes it better?
Mr.
Go ahead.
Well,
No.
What I'm going to say is that Mr. Graham was unaware of the warrant and that this was pending. However, there's no allegations that I have heard that there's been anything since that July 2025 incident. So in 6 or so months.
Motion for bond reduction is denied. Bond will continue. Thank you.
The final ruling in this hearing is clear. The judge denies the request for bond reduction. Despite the defense's arguments about housing, employment, and family responsibilities, the court ultimately decides the risk factors outweigh those improvements. The prosecution's mention of threatening messages, including the alarming statement that one of us is about to die tonight, clearly played a major role in that decision. Even though those messages were months old, the judge views them as a serious indicator of potential danger. In the legal system, judges must always weigh two things: the rights of the defendant and the safety of the community. When statements suggesting violence appear in the record, courts are often extremely cautious about releasing someone. So today's hearing ends with multiple outcomes: continued treatment under strict supervision for one defendant and continued custody for another. Cases like this highlight how complex the justice system can be. Every decision involves balancing evidence, personal circumstances, and public safety. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.